family, marriage, they seem like such fundamental, uh, universally understood ideas. We all think we know what they mean. But when you look at them through a legal lens, especially in countries like Uganda, countries navigating this blend of deep-seated traditions and, well, the demands of modernity, these concepts are anything but simple. They're layered, historically complex, and constantly evolving. Today, we're taking a deep dive into the fascinating and ever-changing landscape of family law in Uganda. We've compiled a really rich stack of sources for this, everything from foundational legal statutes like the Marriage Act and the Divorce Act to extensive case law that really reveals how these laws are interpreted in real life. We've also integrated insights from scholarly articles and even crucial international human rights documents like the African Charter on the Rights and Welfare of the Child. So our mission today is to extract the most important nuggets of knowledge from all this material, uncover some perhaps surprising historical facts, and give you a clearer understanding of how family structures, marital unions, property rights, and even relationship dissolutions are legally defined and managed in Uganda. And of course, we'll explore the ongoing, often challenging push for vital reforms. Just a quick note before we jump in, we did see one document in our research that touched upon certainties in trust law. Interesting stuff, but that's a different area of legal practice. So our core focus today will remain squarely on the intricate web of family and marriage law as presented in our other comprehensive sources. Let's get started. You might intuitively understand what a family is, right? But legally, its definition is surprisingly nuanced and has actually changed significantly over time. So how does the law actually define family?
That's a great question because our sources show just how much variety there is in that definition. Traditionally, legal scholars like Bromley defined a family as, a basic social unit of at least two people. This could be a husband and wife, two people living as if married, a parent with children, or even other relations like, say, a brother and sister.
Okay, the basic unit idea.
Right. Then, from an international human rights perspective, documents like the African Charter on the Rights and Welfare of the Child and the Universal Declaration of Human Rights describe the family as the natural unit and basis of society and the fundamental group unit. This really emphasizes the state's obligation to protect it.
A foundational role.
Exactly. And what's particularly striking is how the legal bond of family can endure even when relationships change. The Hendricks v. Netherlands case, for example, highlighted that while divorce legally ends a marriage, it cannot dissolve the bond uniting father or mother and child. That foundational parent-child connection, it remains.
That's powerful. Divorce doesn't sever that tie.
Precisely. And if we look at the evolution through case law, we see how definitions have expanded. Think about the contrast between the pretty restrictive 1950 view in Gammons v. Eakins. That case actually referred to unmarried couples as masquerading, not family.
Wow, masquerading. Strong language.
Yeah. Compared to the landmark Fitzpatrick v. Sterling Housing Association LTD case from 2000, that case was groundbreaking. It broadened the definition to include a gay couple as a family based on factors like mutual interdependence of the sharing of lives, of caring and love, or commitment and support. This shows a clear legal trend towards recognizing less formal relationships as family if they demonstrate, genuine intimacy and stability.
So these shifting legal definitions, they have real-world implications for your rights, your protections, and how your relationships are recognized socially. Now, if family is complex marriage, well, that has its own layers of legal interpretation, too.
Absolutely. That classic legal definition of marriage, established way back in the Hyde v. Hyde and Woodhouse case in 1866, it describes it as the voluntary union for life of one man and one woman to the exclusion of all others.
Right, the one most people think of.
Exactly. But it's really important to understand that in Uganda, this is more of an ideal promoted by the law, not a strict literal definition that applies to every single union.
Why is that?
Well, because Uganda legally recognizes polygamous marriages and divorce is certainly possible. So for life and exclusion of all others aren't absolute requirements in every context.
Got it. So the ideal versus the reality on the ground.
Precisely. What's crucial to note, though, is that Article 31 of Uganda's constitution explicitly grants men and women of the age of 18 years and above have the right to marry and to found a family. This establishes marriage as a fundamental right for its citizens.
Okay. A constitutional right to marry.
Yes. However, the legal emphasis on marriage being between a man and a woman, as defined by their biological sex at birth, was underscored by the Corbett v. Corbett case in 1970. In that case, a marriage involving a person who had undergone sex change surgery was declared void, reinforcing that sort of biological understanding at the time.
Interesting. So the biological sex aspect was legally significant.
It was in that specific context. Now, in Uganda, marriage broadly falls into two main types. You have monogamous marriages, which include church and civil marriages, primarily governed by the Marriage Act. Then there are potentially polygamous marriages, such as Mohammedan and customary marriages, which are governed by their own respective acts and laws.
Okay, that's clearer. Now this gets really interesting. Before a couple even says, "I do," the law often steps in. What are some of those crucial preliminary steps and promises that need to be navigated before the actual ceremony?
Right. Well, traditionally, a promise to marry was actually considered a legally enforceable contract at common law. You could potentially sue for damages if it was broken. Seriously. You could sue over a broken engagement.
Historically, yes. However, in Uganda today, you generally can't sue for the breach of an agreement to marry between the intended spouses themselves. But if gifts were exchanged, like an engagement ring, the implication is they should be returned if the agreement is broken. This was affirmed in a pretty old case, 1928, Fazaldin Sadruddin v. Din Muhammad and Hajra Begum.
Okay, so no lawsuit for heartbreak, but you might get the ring back.
Basically, yes. Now, when it comes to formal marriages under the Marriage Act, there are specific preliminaries. These are designed for public awareness and proper record keeping. One party needs to give notice to the registrar in the district where they've lived for at least 15 days.
Okay, the notice period.
Yeah, and this notice is then publicly recorded and published. Makes it official, lets people know.
Public knowledge. Makes sense. Then the ceremony itself has clear requirements. It must be celebrated with open doors, so publicly accessible between 10 a.m. and 4 p.m., and it has to be in the presence of at least 2 witnesses, besides the officiating minister or registrar. Afterwards, a marriage certificate is issued and filed.
So, quite formal.
Very. And these formalities serve vital functions. They underscore the seriousness of marriage, ensure public awareness, provide that formal record, and allow for any objections to be raised. In fact, using a false name with fraudulent intent during this process, particularly when publishing bans, those public announcements, can actually void the marriage. We saw that in cases like Small v. Small from 1923.
So honesty is key, legally speaking.
Definitely. Now, for Mohammedan marriages, the primary requirements are a bit different. They include mutual agreement known as ijab uqwal between the bride and groom,
Mutual agreement, okay?
the presence of 2 adult insane witnesses, and the mar, which is a marriage gift from the groom to the bride. It's important to note that Islamic marriage is considered a solemn but revocable social contract, not really a sacrament in the same way.
A social contract. Interesting distinction.
It is. And then we have customary marriages, which are legally defined as potentially polygamous. Key elements here include bride wealth, which is generally understood today as a token of gratitude, not, a purchase price. And critically, the requirement of free consent from both the couple. This aligns with constitutional provisions, as reinforced in Pamela, Sabina, and Babazi v. Henry Bazira back in 2004.
Free consent is crucial everywhere, it seems.
Absolutely. Now, the age requirements differ slightly here. While the Constitution sets 18 as the general age for marriage, customary law traditionally set it at 16 for females and 18 for males, though the constitutional age is paramount. And what's particularly important to remember, something established in Nasanga v. Nyonga in 1977, is that simply not registering a customary marriage doesn't make it invalid. It's still a marriage.
Okay, so registration isn't the thing that makes it legal. The custom itself does. That's a profound look at how the law defines family and the very foundation of marriage.
Right.
But what happens when that foundation has cracks, or maybe it was never truly laid? The law has fascinating ways of categorizing unions that might not be real from the start or those that can be undone later.
Right. And that's where the distinction between a void and a voidable marriage becomes really crucial. Cases like de Reneville v. de Reneville helped clarify this. Think of a void marriage as one that legally, it never existed right from the beginning. It's like it was a ghost marriage, and you don't even need a formal court order to declare it so, though often people seek one for clarity.
Never happened at all, legally. What makes a marriage void?
Often it involves fundamental flaws that make the union legally impossible from the get-go. This includes situations where the ceremony knowingly or willfully takes place in an unauthorized location or by an unauthorized minister, or if false names are used with intent to defraud. It's also void if the parties are too closely related by blood that's consanguinity, or by marriage, which is affinity.
Prohibited degrees of relation.
Exactly.
Yeah.
Or if one party was already married, for example, by customary law, when they entered into a subsequent Marriage Act union, that second one is void. And importantly, if a party lacked the mental capacity to understand the duties and responsibilities of marriage at the time, perhaps due to severe mental impairment or being deemed a lunatic or idiot under the older language of the Divorce Act, it's also considered void.
Lack of capacity.
Yes. Interestingly, though, tribal or clan prohibitions, like those we saw discussed in Kibuwa v. Namatsi in Uganda Christian University, they generally don't invalidate a marriage celebrated under the Marriage Act if it otherwise meets all the legal requirements of that act.
So the statute overrides those particular customs in that context. Okay, what about voidable?
A voidable marriage, on the other hand, is considered valid and subsisting until a court specifically pronounces a decree of annulment. It's like a building that's standing but has a hidden structural flaw. Someone needs to point out that flaw and get a formal order for it to be essentially condemned or torn down. It was real up until that point.
Okay, so it exists unless challenged successfully. What are the grounds?
Grounds for voidable marriages often involve issues with consent or the ability to fulfill marital duties. A major one is non-consummation. This could be due to physical or psychological incapacity, like frigidity, mentioned in Clark v. Clark, or a willful refusal by one spouse to have sexual intercourse, as discussed in Horton v. Horton.
Incapacity or refusal.
Right. Fraud can also make a marriage voidable. For instance, the fraudulent concealment of one's true faith, if that was a critical factor for the other party in deciding to marry. Justice Mukasa Kyonyogo ruled on a case like that. And if there was a mistake as to a person's true identity, like in Militante v. Ogunwamuju, where someone assumed a false identity, that could void it.
Mistaken identity.
Or if consent was given under duress, meaning genuine fear for one's life, limb, or liberty. That vitiates consent. However, it's important to distinguish duress from general pressure or unhappiness. Threats of losing a job or income, as we saw in Singh v. Kaur in 1981, were not considered sufficient duress to invalidate a marriage. The law differentiates truly forced marriages from, say, traditionally arranged marriages where there might be family pressure.
A high bar for duress, then.
Yes. And a key takeaway here is about approbation. A void marriage, remember, cannot be approbated. You can't make it valid later by your actions because it never was valid. But a voidable marriage can be. If a party finds out about the defect, knows they could potentially annul it, but then continues to act as if the marriage is fine. Maybe accepting material benefits, continuing to live together.
Yeah.
They might lose the right to have it annulled later. They've essentially accepted it, flaws and all.
So you can lose your chance to annul if you act like it's okay. Interesting. Now, connecting this to the bigger picture, what were the legal effects of marriage, historically and now?
Well, if we look back, marriage profoundly impacted legal rights, especially for women. The 18th century jurist W. Blackstone famously commented that by marriage, the husband and wife are one person in law.
The one-person doctrine.
Exactly. And historically, this often meant the husband had significant power and dominion over his wife. In fact, an 1840 case, Ree Cochran, even mentioned, and this is shocking now, that a husband could technically beat her, but not in a violent or cruel manner. It highlights the stark realities of the past legal framework.
Unbelievable.
And a wife's domestic arrangements, agreements made within the home, weren't always seen as legally enforceable contracts, as the classic Balfour v. Balfour case showed.
So very unequal footing historically. How about modern legal effects?
Much different, thankfully, though echoes remain. In modern law, parties acquire the legal status of being married. This makes them legally incapable of contracting another monogamous marriage, and defines offenses like bigamy and adultery within that marital context. A wife gains the right, but importantly not the duty, to use her husband's name. That was established way back in Fiddle v. Goldsmith in 1877.
Right, not an obligation. Good distinction.
Yes. There's also a rebuttable presumption, meaning it's assumed true unless proven otherwise, that children born during the marriage legally belong to the spouses. That's from Preston Jones v. Preston Jones.
Presumption of legitimacy.
Right. And then there are conjugal rights, or consortium. This legal concept encompasses the right to companionship, society, affection, and sexual intercourse within the marriage. However, courts cannot order specific performance of conjugal rights. They can't force a spouse to live with the other, as established in R.V. Jackson. And crucially, insisted intercourse against a wife's will, even within marriage, can constitute assault, as held in R.V. Miller in 1954.
Important boundaries there. Now, property.
Yeah.
That's always a big one. How does Ugandan law handle property acquired during marriage?
This is a critical point. Uganda currently has no specific statutory law governing property acquired by a couple during their married life or even prior to marriage if it becomes joint property. It's a major gap.
No specific law. So how do courts decide?
Courts have had to develop principles through case law. While historically it was debated, cases like Kivuitu v. Kivuitu from 1985 clearly established that a wife's non-monetary contributions, things like child-rearing, managing the household, looking after the family, do count towards establishing an interest in matrimonial property.
So sweat equity counts.
Exactly. It's recognized. This substantial contribution can even imply an intention to create a trust over the property, as seen in cases like Adira Nakingi v. Melchizedeki. Funds in joint bank accounts are often treated as a common purse if both spouses contribute. And gifts initially given to just one spouse can sometimes become joint property through how the couple treats that property later on.
Behavior matters.
It does. But this lack of clear statutory law creates uncertainty and has led to strong calls for reform. Justice Kisake, in the Julius Rabanumi v. Hope Bahimbisomwe case, very emphatically urged Parliament to enact a law that clearly defines what constitutes marital matrimonial property.
A clear call for legislative action. Okay, let's shift focus slightly to children's rights within this whole legal framework. How does the African Charter fit in?
The African Charter on the Rights and Welfare of the Child, adopted back in 1990, is hugely important here. It serves as a cornerstone for child rights in the region, including Uganda. It places a clear obligation on state parties, the countries that signed it, to realize child rights. And arguably, the most fundamental principle it lays out is in Article 4. The best interests of the child shall be the primary consideration in all actions concerning them.
The best interest principle. That's key in family law globally.
Absolutely. And it directly influences how Ugandan courts are supposed to approach custody battles, inheritance disputes, child protection cases, everything involving children. The Charter also sets out specific protections against things like harmful social and cultural practices, child abuse, torture, sexual exploitation, and discrimination. It establishes a right to free and compulsory basic education.
Important protections.
Very. And it even includes specific provisions for particularly vulnerable children, like disabled children or refugee children, including measures for tracing their parents for reunification. Interestingly, this charter also uniquely includes duties for children, like preserving African cultural values and promoting African unity.
Duties for children, too. That's unusual.
It is quite distinctive. And there's a monitoring mechanism, a committee that assesses progress, formulates principles, and requires state parties to submit regular reports on how they're upholding these rights.
Okay, so how does this connect to the practical issues in Ugandan inheritance law you mentioned earlier?
Well, connecting the Charter's principles, especially the best interests principle, to Ugandan inheritance law highlights some real problems. The existing Succession Act has historically disadvantaged children, especially when their mother is dispossessed after the father's death. You see situations where relatives might take in children, sometimes in the guise of caring, but really it's about accessing the property left behind.
Exploiting the situation.
Potentially, yes. The proposed Succession Amendment Bill of 2006 directly aims to fix this, aligning inheritance law more closely with the child's best interests. The bill proposes several key changes. Granting daughters equal inheritance rights as sons, making the surviving spouse the automatic administrator of the estate, which simplifies things and protects the spouse, and criminalizing widow inheritance, that practice of forcing a widow to remarry, often a relative of the deceased husband.
Criminalizing widow inheritance, that's significant.
Hugely significant for women's autonomy and children's stability. For polygamous marriages, the bill specifically aims to ensure that if one wife dies, her children inherit her half of the matrimonial property while the husband retains his half. This protects those specific children's inheritance. So these reforms collectively aim to uphold the constitutional right of children to live with their biological parents where possible and ensure their welfare is truly paramount when estates are divided.
Okay, so we've talked about forming families and marriages, the validity, the property, the children. But even when a marriage is legally recognized and established, sometimes, well, it comes to an end. How does the law navigate these separations and dissolutions?
Right, the end of a marriage. There are several primary legal mechanisms for dissolution in Uganda. The most straightforward, sadly, is death. That automatically ends the marriage. Spouses can also agree to live apart through a mutual agreement or a formal separation agreement. This suspends some conjugal rights, like the duty to cohabit, but it doesn't actually end the marriage legally. They're still married, just living apart. These agreements often include clauses about maintenance for a spouse or children.
The separation agreement isn't a divorce then?
Correct. Then there's judicial separation. This is a court order allowing spouses to live apart, but again, it doesn't dissolve the marriage. It requires grounds similar to divorce, like cruelty, adultery, or desertion. While judicially separated, the parties remain legally married, but they gain some independence, for instance. They can sue and be sued as if they were single.
So a step short of divorce, but with legal standing.
Exactly. Now, turning to actual divorce under Uganda's Divorce Act, it's crucial to understand its history. This act is old, colonial-era law from 1904, based on even older British law, and historically it was profoundly discriminatory against women. For example, wives used to have to prove aggravated adultery, that meant adultery plus another offense like cruelty or desertion, to get a divorce. Husbands, on the other hand, only needed to prove simple adultery.
A clear double standard.
Absolutely blatant. But a major reform came with the landmark constitutional court ruling in Uganda Association of Women Lawyers v. Attorney General in 2003. This ruling found those discriminatory provisions completely inconsistent with Uganda's 1995 Constitution's equality clauses. The huge impact of this ruling is that now all grounds of divorce are available to both parties to the marriage. It leveled the playing field for grounds.
That's a massive change. So what are the grounds now available to both spouses?
So, the grounds for divorce, now equally applied under Section 4 of the Act as reinterpreted, include, first, adultery. This is defined basically as consensual sexual intercourse during the marriage between one spouse and a person of the opposite sex who is not the other spouse.
Pretty standard definition.
Yes. The burden of proof is on the person alleging it. It's a bit higher than a normal civil case, but not as high as a criminal case. Penetration is required, technically, but courts recognize that's hard to prove directly, so they can use circumstantial evidence. Second ground, cruelty. This isn't just being unkind. It requires serious conduct that causes actual or apprehended injury to life, limb, health, or mental state. The court looks at the whole matrimonial relationship, the pattern of behavior, the impact of one spouse's conduct and personality on the other.
So, serious impact is needed.
Definitely. Third, desertion. This occurs when a spouse leaves the matrimonial home with what the law calls animus deserendi. That's a clear intention not to return. And this state of affairs continues for 2 years or more without consent or justification.
2 years of intended separation.
Right. And interestingly, de facto separation, meaning actually living separate lives, can legally occur even if the parties are still living under the same roof, maybe in separate rooms, not speaking. Reconciliation attempts don't necessarily break the 2-year period unless full cohabitation is genuinely resumed.
Living apart together, in a way.
Sort of, legally speaking. And finally, change of religion. This is a ground when one spouse converts to another religion without the consent of the other spouse.
Okay, those are the main grounds. But are there things that can stop a divorce even if one of these grounds exists?
Yes, absolutely. These are called bars to divorce. Even if you prove adultery or cruelty, the court might still refuse the divorce if certain bars are present. There are absolute bars laid out in Section 8 of the Divorce Act. If the court finds these, it must dismiss the petition. These happen if the person asking for the divorce was accessory to the matrimonial offense, or connived at it, or condoned it.
Accessory, connived, condoned, what do those mean exactly?
Okay, so connivance is essentially where the petitioner actively encourages or willingly helps bring about the offense, like the adultery. Think of someone setting up their spouse. The crucial point is the very beginning of the adultery. If your initial connivance caused it, you generally can't get a divorce for it later, even if it continues. Condonation is forgiveness. It means knowing about the offense, forgiving it, and then restoring the offending spouse back to their previous position in the marriage, usually including resuming cohabitation. If you've truly condoned it, you can't then use that same offense as grounds for divorce later unless maybe the offense is repeated.
So forgiveness can be a bar. What about accessory? That sounds like collusion.
Collusion is actually another absolute bar, often mentioned alongside accessory. Collusion is where the spouses agree to deceive the court. They might agree to invent grounds for divorce or present false evidence, or even corruptly agree to bring forward true facts just to secure the divorce. It's about improperly manipulating the legal process. Being accessory to is similar, implying active participation or assistance in the offense itself.
Okay, so if the court finds any of those, no divorce. Are there other bars?
Yes. There are also discretionary bars listed in Section 8, subsection 2. If these are present, the court may refuse the divorce, but it doesn't have to. It depends on the circumstances. One is unreasonable delay. If you wait for years and years after discovering the offense before petitioning for divorce without a good reason, the court might question why and could potentially refuse the divorce.
Delay can be fatal.
It can be. Another major one is the petitioner's own adultery. If the person asking for the divorce has also committed adultery, the court has discretion. It might still grant the divorce, but it will weigh factors like the interests of any children, the prospects for reconciliation, if any, whether refusing the divorce would cause undue hardship, and the petitioner's ability to remarry respectably. The famous Blunt v. Blunt case laid out these considerations.
So your own behavior matters, even if your spouse also wronged you.
Absolutely. The court looks at the whole picture. Now, beyond the Divorce Act, Islamic law also provides for divorce mechanisms, often outside of court.
Extrajudicial divorces.
Yes. There are three main types. First, talaq, which is initiated by the husband. This itself has various forms. Asan is considered the best. A single pronouncement of divorce followed by a waiting period, iddat, usually about 3 months or 3 menstrual cycles. During this time, the divorce is revocable if they resume cohabitation. Hassan involves 3 pronouncements made over 3 successive months with abstinence in between. It becomes final and irrevocable after the 3rd pronouncement. And then there's bidat, which is an instantaneous divorce, like saying, I divorce you 3 times at once. It's generally considered an innovated or less approved form, though historically practiced.
So different forms of talaq. What are the others?
There's khula, which is a divorce initiated by the wife. This often involves her giving back the mahr or some other compensation to the husband in return for the dissolution. And mubarat, which is divorce by mutual consent. Both parties agree to end the marriage.
Initiated by husband, wife, or mutual?
Correct. And there are specific conditions related to age, consciousness, freedom from pressure for the person initiating it, and recognized grounds like long-term desertion, failure to provide maintenance, imprisonment, or severe conditions like insanity or cruelty.
Okay. And what about customary divorce?
Customary divorce grounds vary hugely depending on the specific community and its traditions. Grounds could include things like the failure to complete bride wealth payments, adultery, witchcraft accusations, barrenness, or even a woman being found pregnant by another man at the time of marriage. It's very specific to the particular custom.
Highly variable then. So after a marriage ends, what happens next? What are the remedies or consequences?
When a marriage is dissolved, several legal remedies and aftermaths come into play. An aggrieved party, usually the husband under the old law, but now potentially either spouse, depending on interpretation, may claim financial damages from a co-respondent, the person their spouse committed adultery with.
Damages from the third party.
Yes, under Sections 21 and 22 of the Divorce Act. Then a crucial issue is custody of any minor children. Here, the guiding principle, echoing the African Charter, is that the welfare of the child is the paramount consideration. Courts generally consider children of tender years, very young children, best placed with the mother unless she's proven to be unfit due to her conduct or circumstances.
Welfare is paramount for kids. Makes sense.
Absolutely. Courts can also order maintenance, often called alimony, for a spouse, and support for children. These orders can be adjusted later if circumstances change significantly, like income changes. And the finalization of the divorce itself involves that 2-stage process we touched on. First, a decree nisi is pronounced. This is like a provisional order. After a specified waiting period, typically 6 months in Uganda under Section 38, if no new issues arise, a decree absolute is granted. That's the final conclusive order. It's only after the decree absolute is granted that the parties are legally free to marry again.
The 2 decrees. And you can't shorten that 6 months.
Not according to case law like Nioji v. Nioji. Ugandan courts have stated they have no power to abridge the 6-month period. It's a fixed waiting time.
Got it. And you mentioned reform is slow here.
Painfully slow. It's worth reiterating that the proposed comprehensive divorce bill, which aims to modernize many of these aspects, grounds, property division, bars, has been stalled for an incredible 47 years.
47 years, wow.
Yes. The delay is partly due to genuinely contentious issues like how to handle cohabitation, fair property sharing, the scope of conjugal rights. But reports also suggest resistance, particularly from some male members of parliament, perhaps due to concerns, rightly or wrongly perceived, about women potentially gaining too much power over property.
Contentious issues and political hurdles. So we've navigated this complex legal system deeply rooted in history and custom. But there's this powerful ongoing call for change, particularly concerning gender equality and protecting the most vulnerable. Why are these reforms so pressing?
That brings us back to the impact, especially of the outdated laws like the Succession Act. As it stands, it severely discriminates against widows. It often denies them clear entitlement to the matrimonial home, the family home they lived in, which frequently passes directly to the eldest son under customary interpretations, granting the widow only a limited right to occupy it, often at the mercy of the heir.
Just the right to live there, maybe temporarily, not own it.
Exactly. And this insecurity can lead to incredibly exploitative practices, including that widow inheritance we mentioned, the forced remarriage, often to a relative of the deceased husband. This strips women of autonomy over their financial, sexual, and reproductive lives and can carry serious health risks, including HIV/AIDS transmission.
A very vulnerable position.
Extremely. Furthermore, as some sources highlight, law enforcement is often inadequate in these situations. Police might dismiss these as domestic issues or family matters, not crimes. This leads to severe underreporting of abuses against widows, who already face immense pressure from relatives not to cause trouble.
Systemic failure is compounding the issue.
Precisely. And these discriminatory laws are fundamentally based on outdated stereotypes about the roles and capabilities of men and women. They fail to recognize women's invaluable economic and non-economic contributions to their families and the acquisition of family property. International and constitutional norms clearly demand that Uganda remedy this inequality. Uganda's own constitution explicitly protects equality and prohibits discrimination based on sex in Articles 21, 31, and 33. And the Women's Protocol to the African Charter explicitly states that a widow should automatically become the guardian and custodian of her children after the death of her husband, unless this is contrary to the interests and the welfare of the children. The law needs to catch up with these principles.
So the legal framework is lagging behind the constitutional and international standards. How does the proposed Succession Amendment Bill try to fix this?
The proposed Succession Amendment Bill of 2006 aims to tackle these injustices head-on. Its key provisions seek to repeal those gender discriminatory sections, explicitly granting equal inheritance rights to widows and daughters, putting them on the same footing as widowers and sons regarding inheritance shares and rights to the home.
Equal rights, finally.
That's the goal. It also aims to make the surviving spouse the automatic administrator of the deceased estate, simplifying the process and giving them control, rather than potentially an antagonistic relative. Crucially, it seeks to criminalize widow inheritance, defining it clearly as forced remarriage without genuine consent to all the essential requirements of marriage.
Putting teeth into stopping that practice.
Exactly. The bill also proposes increasing criminal penalties for interfering with the rightful administration of an estate, protecting beneficiaries. And it mandates training and education programs for police, magistrates, judges, local government officials, as well as public awareness campaigns to ensure everyone understands and enforces women's constitutional rights in these matters.
Education and enforcement, key parts.
Vital. And for polygamous marriages, remember, the bill aims to ensure that if one wife dies, her children inherit her half share of the matrimonial property acquired during her marriage, protecting their specific lineage and arguably discouraging polygamy by ensuring property division respects each wife's contribution and her children's rights. But again, connecting this back, while this succession bill addresses inheritance, the broader divorce bill, which covers many related family law issues, remains stalled after nearly 5 decades. It highlights the incredibly slow and challenging pace of comprehensive legal modernization in this sensitive area.
What an incredible journey we've just taken through the really intricate world of family law in Uganda, from the evolving definitions of family and marriage to the deeply rooted customs and the ongoing difficult fight for gender equality and property and divorce. It's just so clear this is a legal landscape that's constantly adapting, albeit, as you say, very slowly sometimes.
Indeed. It really highlights how legal frameworks aren't static things, are they? They're living reflections of societal values, historical influences, political struggles. Understanding these complexities is vital, not just academically, but because they profoundly impact the daily lives and the fundamental rights of individuals and families on the ground.
Absolutely. It touches everyone.
It really does, and it makes you think. As legal systems everywhere grapple with modernity, trying to strive for greater equality and protection, what unspoken social contracts or deeply ingrained cultural norms in your own society, whatever you are listening, might be silently influencing personal rights, responsibilities, or even the very definition of family, things operating just beneath the surface of the formal law.
That's a really powerful thought to end on. What's shaping our own realities under the surface. It means there's always more to learn and definitely more to question.